Thank you, everyone. We'll let everyone else trickle in, but we'll get the show on the road. Welcome. This is Rembrandts in the Attic, Unlocking Patent Monetization. This is the first in a series of presentations put on by Saul Ewing that is a collaboration between our IP department and our higher education department. So really focusing on that intersection between universities and IP. There's a lot to talk about. This is a offshoot of some interest from our IP executive series, and so here we are. I am one of your hosts, Veronica McCarty. I'm an associate here at Saul Ewing, and with me is, there on the screen twice, is Brian Mahalik, our partner and co-chair of our IP group. With that, if we could go to the next slide. So yes, just a few webinar housekeeping notes. For questions, there is a Q&A. There's a Q&A tool at the bottom of your screen. If you have questions as we go through the presentation, please feel free to submit them. We will do our best to answer them as they unfold. If we don't get to your question, we'll review at the end and we'll try and send you an email with the answer. Credit. You do get credit for coming to this presentation. You do get CLE credit. We will be giving out the codes during the presentation, so stay tuned. You'll see the code appear on the screen. We will repeat it. If we could just go back to the last slide, and then I'll get to that in a second. Obviously, we'll be sending a follow-up email after this presentation with all the materials, as well as information about our upcoming webinars and series. And of course, the disclaimer, this is not legal advice. This is a presentation. None of this is legal advice. It does not create an attorney-client relationship, but it could. Reach out to us afterwards. Okay, with that, next slide, please. So yes, CLE requirements. There will be a QR code and link at the end of the event. Once you see that QR code and link, you can scan it, you can click it, and you will enter the CLE codes there. You will enter your jurisdictions that you need to be licensed, and email confirmation will be sent. I'm sure everyone's been through this before. It is the typical procedure, but be sure to have that code handy. And with that, next slide, please. I believe we're ready to begin. Please take it away, Brian.
Yeah, thank you very much, Veronica. Can you hear me okay?
I can hear you great.
Thumbs up. Well, excellent. Well, good morning to some of you and good afternoon to others. And thank you for joining us today. We've got a really fun and exciting kind of presentation today. And I think the title's a real fun one for us. Rembrandts in the Attic. It comes from an intellectual property book that's been written more than 25 years ago, around the turn of the century, around 2000, and was called Rembrandts in the Attic. And its core principle, its core idea is something that's simple, but I think powerful, which is that you may already own something that's extremely valuable, but you just don't realize it. And just like if you're discovering a genuine, authentic Rembrandt in your attic, many organizations sit on valuable intellectual property, particularly patents, without fully understanding or monetizing what they have. And if you look here at the slide, actually, interestingly enough, in recent years, the book title actually mirrored reality in 2024, when an auctioneer discovered an authentic Rembrandt painting called Portrait of a Girl in the Attic of one of his clients while he was making a house call. And they ended up selling that painting for $1.4 million at auction. So I just thought that was kind of interesting where kind of literature mirrors real life, as it kind of highlights the context for this discussion today. If we can go to the next slide. I want to give a very brief prologue for what we're going to be talking about today, specifically as it relates to intellectual property and in even more specificity with respect to patents. When we're talking about Rembrandts in the Attic, it was a book that was co-written by authors who both had experience working at IBM. And while the book provides various and different examples of what these patent Rembrandts are, perhaps the premier example was IBM in the 1990s. During this time, IBM held what some estimated to be around 2,700 patents, and they were all directed to an eclectic and a diverse technology scope. And at the time in the 1990s, there was a lot of disorganization, and these patents were sitting on a shelf and really just a cost center for IBM. They were paying a lot of maintenance fees, they were paying prosecution fees, and there was really a lack of direction. It was a bit rudderless. So, recognizing this as a problem, IBM flipped the script on its strategy and it transformed its patent portfolio into what amounted to a $2 billion a year licensing business. But of course, this didn't happen overnight. A lot went into it, and it was a result of what what was IBM's strategic decision and deliberate process, a process that included, I'll say, internal auditing and organization of their patent portfolio, as well as the technologies thereof. And it focused also on understanding what the past, the present, and the future technology marketplace look like. And probably importantly, it ditched kind of the old mindset from that time period of the, what I call file and forget it mindset. So often was the case with those types of companies in the 90s, they were just filing applications without any real strategic purpose or strategic strategy for what they were going to do when those assets would actually mature into issued patents. So they ditched that mindset as well. And those efforts led not just to a strategic business result, but I think they also, in my opinion, sparked a paradigm shift within the IP and patent community. And granted, this IP and patent market is dramatically different today than it was in the 2000s, but I think there are a lot of interesting lessons that we can learn from those earlier practices using IBM as an example as applicable here today. So we'll go to the next slide, and Veronica's going to tee up the agenda for us. But I think we're going to have a really interesting discussion today. So thanks for joining.
Thanks, Brian, for that prologue. I will just briefly go through the agenda that you are all about to experience in the next hour or so. We are going to briefly cover the world and the universe of university intellectual property. What are we talking about? What are we covering? The focus of today's presentation will be on patents, how to monetize and protect with patents. We're going to go through some real-life case law examples, enforcement trends, other examples of beyond simply, direct patent infringement suits, other examples of monetization and protection of your patent assets. And Brian's going to give a really interesting presentation on University Alpha, which is a case study from the firm. I will then be taking over and I will be discussing the intersection between NIL rights, how that is a Rembrandt in the attic and a hidden revenue generator, and trademark implications that has for trademarks and things universities really need to watch out for. We'll transition right into the challenges facing universities and tech transfer offices. Throughout the presentation, our goal is to give real-world examples so you can really understand where this fits in for your practice, whether it's a law firm or a tech transfer office, and new and exciting ways to think about monetization. And with that, we can go to the next slide. So, the world of university intellectual property. It's a large universe that everyone, I'm sure, on the call is grappling with every day. I am just going to cover very briefly the general buckets. We have our copyrights, we have our trade secrets, we have our patents and our trademarks. Patents and trademarks through NIL rights being the focus of today's presentation. we're going to be looking at patent monetization and again, NIL rights and the interplay with university trademarks. If we could go to the next slide, please. All right, and with that, Brian Mahalik, back to you.
Yeah, so let's get right into it. And by the way, if there are questions, we do have some time at the end to field some questions. But if something comes to you real time, feel free to place it in the chat so that we can queue it up and try our best to address whatever it is, and we can handle it that way. So the chat will be your friend for that function today. Um, so with all that being said, I think the big question remains, well, how do I monetize and protect my assets? And in the coming slides, we're going to talk about answering that very question. And maybe not so surprisingly, there's going to be many different ways to answer it. But our hope is to provide you with, and we can go to the next slide. Our hope is to provide you with a variety of different methodologies and talk through some different examples. So in particular, we're going to talk about some examples of universities who have already successfully identified and monetized their Rembrandts through a monetization campaign. Then we're going to walk through an actual example of how our firm has dealt with this type of monetization strategy, portfolio triaging and mining in the past, and provide that as an example for what a potential monetization opportunity might look like. As Veronica already indicated, that's what we're calling University Alpha, which we're going to get to later on. So let's go to the next slide where we're going to talk about a couple recent examples that I think are worthy of discussing within the context of this university and Rembrandt's discussion. So if we turn to the next slide, perhaps one of the more recent examples has to do with the California Institute of Technology. In particular, Caltech's been very successful in litigating and licensing some of its Rembrandts. And we see this most immediately in its settlements against Apple and Broadcom. But I think if you unpack that a little bit more, you'll see that the Caltech story here closely aligns with the IBM example that we started with in the prologue. And what I mean by that is the relevant Caltech patents, they were actually directed to a major breakthrough in what is called error correction coding technology, which this has to do with basically fixing corrupted or damaged data as it's wirelessly transmitted from one point to another. That aside, the story really begins with Caltech professor Dr. Robert McGillis and his graduate assistants, whose research was really very early on focused on this error correction technology. In fact, for these particular patents, the priority dates really go back to the turn of the century, around 2000. And I think this was an example of Caltech properly understanding the developing market because in the year 2000, there really was not a tremendous market for the speed, for the efficiency, for the accuracy of wireless data transmission. It just wasn't there yet. Obviously, though, this changed over the years as the technology market developed, as smartphones started becoming more ubiquitous, and the need for data triumphed. All of a sudden, the market started incorporating and building itself around this error correction technology. There was quite frankly just a lot more need for data to be transmitted, and for not just that, data to be transmitted in a way in which it was accurate and free from corruption. So, in particular, with respect to the Apple and Broadcom case, Caltech realized, through its own internal auditing and analysis that, there were hundreds of millions of chips that were going into these smartphones, which were using its technology. And the end result was a successful monetization and licensing strategy. In particular, the Apple Broadcom case resulted in a $1.1 billion jury verdict. Now, recognize that verdict was, in fact, vacated and remanded by the Federal Circuit, as the Federal Circuit sometimes does. They found a problem with the damages analysis that Caltech applied. It basically applied this two-tier damages analysis that they didn't like. So they said, let's go back to the district court and do it again. But the leverage was already set, and Caltech was able to confidentially settle that matter months later during the process of remand. And while those settlement numbers are confidential, I think all kind of indicators and all kind of signs point to what would be a very successful monetization campaign for Caltech with respect to the Apple and Broadcom case. But I think there's even a bigger picture here because it wasn't just Apple or Broadcom, but Caltech had recognized that their technology was foundational, it was seminal, and now it was ubiquitous with the evolving market. And they also enforced their rights against entities like Samsung, like Dell, Hewlett Packard, Microsoft, and most recently, Zoom Communications. So again, while most of the final settlement information is confidential, I think it stands to reason based on the settlement posture that it's very likely and fair to consider this a successful example of a monetization campaign. And when you unpack it a little bit more, you see that this monetization for Caltech may never have realized unless it proactively kept its finger on the pulse of its own intellectual property within the evolving IP market. So I think this is a really good example of something recent to demonstrate not just the end result, which was positive, but also the process that was implemented to getting to that end result. So with that, I'll turn it over to Veronica, who has, I think, another example or two to discuss.
Thank you so much, Brian. Yeah, can we go to the next slide, please? Thank you. It's keeping along the theme of patent monetization, I think the next two cases are particularly interesting, not just because they show how patents can be used, universities are sitting on these assets, and that patents can be used for monetization, but it's not just about revenue all the time. It is coexisting with the enforcement of protecting your patents and protecting your rights and a larger litigation strategy. At times, that is a global strategy where the patent monetization route or the patent infringement suit plays a very big role in that. And the trustees of the University of Pennsylvania versus Gentech Inc. is an example. My alma mater, University of Pennsylvania, although that's not why we picked this case, but it went very well for them indeed. This was a suit over 4 of Roche's breast cancer drugs, so Herceptin, Hylecta, Perjeta, and Phesgo. There was only one patent at issue, the 558 patent, which was developed at Penn's Abraham Cancer Center. It covered a method of treatment for an ERBB protein, protein-mediated tumors by administering an antibody following radiation treatment, followed by radiation treatment, excuse me. Now, this case settled shortly after dispositive motion practice, where defendants lost summary judgment for non-infringement and non-invalidity. We don't know the settlement amount. It was not disclosed, but it's very notable because the parent Roche here, the parent company, had previously filed 3 European oppositions to the issuance of the 558 patent's European counterparts. This was actually a suit that, even though it was filed in 2022, had roots back into 2007. They filed 3 European interference proceedings oppositions in 2007, 2012, and 2019. So there's a long-standing dispute here over the 558 patent and the 558 patents family. And it gets resolved in this patent infringement case. So this is a really good example of not just monetizing your patents against an infringer, someone who obviously has had their eye on your patents for quite some time, but a very effective way to end a global dispute once and for all through this mechanism. So not only are you making money, you're protecting your patent rights as well. Can we go to the next slide, please? Similarly, there's a similar theme in Regents of the University of California, Berkeley, versus Surgical Science North America Corp. Again, it presents as a traditional patent infringement case, but there's something deeper going on if you look beneath the hood. So this was a case where the university sued defendants' ultrasound simulation and training products, which they alleged infringed 5 of their patents and was a breach of prior licensing and settlement agreements. So here we had a 2017 settlement agreement and an NDA for licensing of these patents. Defendants, interestingly, this suit was actually a reaction to a suit defendants had filed. Defendants had filed a declaratory judgment action in the Northern District of Ohio seeking a ruling of non-infringement. In response, Regents files this patent infringement suit. Now, this case is ongoing. It was just filed in June, so there's a motion to dismiss, Senate transfer venue on the table. But it is a good reminder that patent infringement suits cannot just be about monetization, although there is certainly a good number. There's a good number on the table here. It's about enforcement of your rights. So the idea being that this can be a dual mechanism, I think, is important when thinking about the strategy and the monetization as well. It can be more than one thing. And with that, we're going to go back to Brian. I know that wasn't quicker than perhaps anticipated.
Yeah, I think we can go to the next slide. Well, it may have been quicker, but I think it goes to kind of one of the overarching themes here, which is that it does appear that universities recently, or more recently, are taking a real hard look at their intellectual property. What we've done here are just pulled together, a few more examples of different universities who have asserted their patent rights over the last 5 years. And I think as we go through these slides, what we see or what we can kind of conclude is that there's no real specific alignment as to like this is a particular technology that is being monetized, or this is a particular university that is doing all the monetization. Rather, it's a pretty broad scope, both with respect to technology rights as well as the university. So, we have a situation where Northwestern University in Chicago has asserted its patent rights against Mitsubishi Electric. These patents here are directed to basically robotics, AI-related type robotics. And as Veronica actually mentioned on the slide before, not all of them, but there are university enforcement campaigns that we are aware of and have been involved with that aren't just straight patent infringement cases, but oftentimes can have a flavor of a breach of contract or some type of commercial transaction gone wrong that is part of or in parallel with the patent infringement campaign as well. Going back to the slide, we see New York University has patents asserted against a company called ResMed Inc. That had to do with a diagnosis and treatment of different sleep disorders and breathing patents. Purdue University had a very popular case or notable case against ST Microelectronics that was in the semiconductor space. University of Pittsburgh was another one. Their patents were for wireless energy transfer. The defendant there was Kochler. We move to the next slide. Thank you. We have some more, right? Some names we've already discussed, like the University of Pennsylvania, right? We just talked about the Gentech case. University of Michigan and the University of South Florida combined forces. They have an infringement case filed in 2022 regarding the combining of active pharmaceutical ingredients against Novartis. There's a really interesting one in 2023 where, again, it was kind of a combined effort. SUNY, which is the State University of New York uh, system, as well as UConn and WPI, had a case against Samsung Electronics. Again, the technology there is dramatically different than what we've talked about before. This is for an algorithm and devices for physiological function detection. The University of South Florida, that's another example of a university asserting patent rights. And their technology was for ground penetrating radar systems and methodologies. Again, we had another Northwestern case that was vaccine related against Moderna. Let's go to the next slide. UT, University of Texas, had a medical treatment case against in the pharmaceutical space. Cornell University, wireless communication technology company, technology patents against AT&T, Verizon. Uh, Southern California, and then Carnegie Mellon University too has a case recently filed as a couple months ago against Uber. And many on the call may remember Carnegie Mellon is not a newcomer to this space. They, of course, had a very large and notable litigation against Marvell Semiconductor about a decade ago. So they're constantly thinking of different ways where monetization might make sense to them. But I think to kind of sum it all up, I think what we're seeing in the marketplace, these are just some of the examples. It's not fully inclusive, but it's just some of the examples of universities that are taking proactive stock of its IP and patent inventory, um, keeping close ties and communications with its professors, with its graduate students, as to the research that they're doing as it relates to the evolving marketplace, which seems to be evolving even quicker these days, and deciding to pursue such rights within those markets. So I think this is a nice cross section to help provide those examples and show that thematically. I'll transition it back to Veronica for the next slide.
Thank you, Brian. I think a theme that we're definitely establishing, or hopefully definitely establishing, is that this practice is much more common, I think, than people really understand and realize. And as you say, there's a lot of different ways to go about it, including, if we could go to our next slide to see another example. So the UTLP, which is the University Technology Licensing Program. I am not just naming things that Penn is involved in, although Penn is involved in the UTLP, as are all the Ivies. This is a patent pool. It was developed in the early in 2020. 15 universities coming together to form a patent pool for licensing and monetization. The pool itself covers a wide range of technologies. It's not intended to cover SEPs, although that is part of there is coverage for that should patents in there turn out to read on SEP technology. But the pool covers the Internet of Things, big data, large-scale data analysis, and autonomous vehicles. Interestingly, in 2021, shortly after this pool was formed, the Department of Justice gave it antitrust clearance. Not a lot is publicly available about the UTLP's maneuverings. There's no publicly available data about settlements or licenses. They have not been involved in any lawsuits, but it is still going and is still going strong. And from my understanding, it's been a successful licensing entity. So this is just one other way in which we see universities taking a hold and getting their arms around their IP to figure out a way to effectively monetize. If we could go to the next slide. Another example are MPEs. So another route that some universities are taking, and I'll get into the data a little bit, but I think it's more than people realize. or universities may give exclusive rights to a non-practicing entity to file suit and monetize their IP rights. An example of this is Arizona State University. There is a lot of growing interest here. Particularly litigation funders are very interested in either purchasing patents directly from universities or setting up MPEs on the university's behalf in order to enforce patents. Arizona State, I've already mentioned, is an example. Another example is the University of Texas. There was a study from 2020, F. Cavigioli et al. In the Technological Forecasting and Social Change Journal, which actually looked at universities and what they're doing with their IP from a period of 2002 to 2010. The study showed that the University of Texas in this time frame actually sold about 53 of their patents. And they were not alone. In fact, the same study found that 3% of universities' reassignments of their intellectual property from 2002 to 2010 were to MPEs. So perhaps quietly, but it really does appear that everyone is doing this. It's so much more prevalent than I think people assume. But again, 3% of university reassignments of intellectual property from 2002 to 2010 to MPEs. Can we go to the next slide, please? This is the slide that everyone is happy to see. It's right around the halfway point. So 98712 is our first code of the day. 98712. I will leave that up there for a moment so that everyone can grab a pen and write it down. And to tie, while everyone is writing down the CLE code, to tie back in my previous point, patent pools and MPEs beyond just traditional patent enforcement, that is, again, another lever to pull. It's another inventive way to go about monetizing your IP. But how do we get there, and how do we do that, and how do we even look at our assets in order to be able to do that? My colleague, Brian Mahalik, is going to give you a real-world example of how this is done. How'd you like that transition?
Yeah, brilliant. I'm happy to do so. But you hit on an interesting point, though, right? There's many different ways to skin a potato here, depending on what you want to do with your intellectual property or patents, depending on what the market looks like, depending on what you as a university, what your parameters are, and what your goals and initiatives are. And I always like to say that, there's different tools in a toolbox. And I think, the two that you just provided, Veronica, with the pool example or the sale or acquisition example, are just two tools, right? And then there's other tools, where the university, like the examples we just ran through with Caltech or Northwestern or anyone else listed on the slide, they're fine pursuing their rights in their own name.
Yes.
It ultimately depends on what you're trying to achieve and who you are.
Mm-hmm.
But for the purpose here, I thought it might be interesting to our group here if we provided just a case study on a client that we had. We're calling them University Alpha, but that came to us with kind of a lot of questions that maybe some other folks on the call have as well, namely surrounding on the fact that we have this patent portfolio. We spent good amount of time, good amount of money on it. What do we do with it? Or what are some strategies that we can implement to put it to use? So drawing all the way back here to that IBM example that we started with, for this University Alpha client, we really stole a page from, the Rembrandts book or the IBM book. Because like IBM, this University Alpha had a significant patent portfolio that had been lying dormant and generally acting as a cost center through the payment of maintenance fees, the payment of prosecution fees. And University Alpha came to us and really needed a game plan to help change the direction and understand potential monetization opportunities. So through this case study, we'll walk through this one example of what became an effective organizational framework for identifying high value patents, that is the Rembrandts that we're talking about, as well as the process that we implemented for University Alpha to prepare its monetization strategy. And again, like they say, there's plenty of ways to skin a potato because that exact framework, it's going to vary. It's going to change depending on who you are as a university, who you are as a corporation, and the nuances and the uniqueness of your portfolio, your research strengths, as well as your priorities in what you hope to accomplish. But our hope is that this example should give you a practical sense of how to approach these assets in a more systematic framework for achieving whatever your goal may be. So if we can turn to the next slide, please. So with respect to University Alpha, we started with kind of the most basic question, which is what's our denominator? What are we actually working with here? In other words, let's try to identify every potential relevant asset. And for university, there were a lot actually. For University Alpha, we had roughly 900 patents, both in the United States as well as foreign. Now, that number might seem big, but a large chunk had been expired already or were part of you know a portfolio that had been very early in time and really wasn't in play anymore. But we still started with the full denominator because we really wanted to get an understanding of specifically the university, where they had focused their research efforts before, and where they were focusing the research efforts now and then into the future. And again, so we performed, I know most universities do keep this information readily available, but we wanted to perform this comprehensive search for those reasons to also understand the different assignments and chain of title review across the entire intellectual property holdings, just to make sure everything was clean and properly documented, but also so that we weren't missing anything as we learned about the portfolio and came up to speed on that. And I think it was actually pretty helpful because it actually allowed us to put eyes on the portfolio very early and have a discussion about specifically the different technology buckets that were going to be involved. So let's go to our next slide here. There we go. So identifying the assets, step one, that's an important part. But once you do that, I think the real work begins because it can be a very difficult process in trying to pare things down from, a big number to a more manageable number that's going to form the crux of a potential patent monetization endeavor. So I think the real work begins there. You need to figure out how to organize and how to prioritize hundreds of these assets. So again, drawing inspiration from the IBM example, we needed a smart way to break down essentially 900 assets without getting tangled up in the details. So in this case, University Alpha gave us some helpful insight to organize based on timing. So essentially, we compile the priority dates, the filing dates, the expiration dates, and we organized the University Alpha's portfolio based on patent term, essentially assessing a durational risk. And here's what we found. Roughly half the portfolio, like I mentioned earlier, roughly half the portfolio, nearly 400 assets, were already expired or were nearing expiration within the next couple of years. So these obviously carry a higher durational risk and have a much more limited life for monetization. So in this particular instance, it was helpful to categorize them in that way and essentially put them off to the side as we evaluated the rest of the portfolio. We found that about 30% of the assets had about 5 to 10 years of term remaining. So for University Alpha, this was the particular sweet spot, I'll say, the Goldilocks zone. And the reason I say this is because it was based on some very specific information and specific nuances that we received from the client about the university and its particular areas for which it focused a lot of its research. But with respect to this 30%, this 5 to 10 year term remaining, these patents really are mature enough that it is a sweet spot, as I said, because the market has had time to develop around the technology, yet they still have enough runway left to deliver the potential of meaningful value through a potential licensing campaign, partnerships, or some other type of strategy. And then with respect to the other remaining 25%, those were more recently filed in the last couple of years. And again, there's no rule saying that if you file it, you have to wait. But generally, we felt that based on this 25% here, there was going to need to be some type of time for the market to adopt the technology. And, typically that requires a little bit longer horizon before their full potential is realized. So really, given that analysis, we concentrated our efforts on, the 30%, I'll call it the sweet spot or the Goldilocks zone, because for this particular university, that's where we saw the highest probability of uncovering actionable opportunities. So let's go to our next slide. So we did the durational aspect. We also did it based on technology as well. We broke things down based on loose buckets that would help us with categorization. And we used a few things to help us with this bucketing exercise. We used the USPTO classification codes, which were somewhat helpful as a tool. We've started to use some AI tools from vendors that provided a little bit more of a help on the lift on identifying some of the technology and evaluating the buckets for the technology. And then importantly, we also talked to our client, as well as some of the professors, if needed and available, to really put a finer point on the potential technology and how we could group them into buckets. And for the purposes of this kind of breakdown here, I can say it turned out about 30% of the assets fell into what I would call the semiconductor or the chip related technologies, which was actually good because it aligned pretty nicely with one of University Alpha's core research focuses. Another 30% were in what we called life sciences, and the final 40% was more of a catch-all. It related to mechanical, electrical technologies like wireless communications, cybersecurity, electronics, and other areas. So with this part, we've basically got two breakdowns. We got a durational breakdown and we've got a technology breakdown, which helped us form pretty key information about triaging and mining this portfolio. So if we can go to the next slide. So with these data points, like I said, we have a durational cross-section of the portfolio that is patents with 5 to 10 years of life. And we have a technological cross-section. And that really helped us provide, or I should say, that really helped provide us with some strategic direction for which rock to look under for where we could focus our efforts. And again, coupled with that triage, we collaborated with the university for directional guidance. We worked with key professors, key inventors. We interviewed graduate students involved in the research, if available. And then we evaluated other helpful indicators such as research spending, what were the ongoing university programs. We identified any potential spin-off companies or commercialization efforts already in place. And we also took a look at potential or existing encumbrances, such as licenses, grants, or other restrictions. Uh, and I mentioned it earlier, there's also some technology that we have used in the past that is available to help with this mining. And in some situations, we've used it. With respect to AI, there are many different, albeit nascent, AI technologies that we've used to provide us some helpful information with portfolio mining, but it ultimately depends on what the goal of the university is or the client is on trying to achieve a monetization effort or monetization campaign. But really, the trick is getting to a point where you can dissect and understand these large portfolios and finding something that's statistically manageable to implement from a monetization perspective. So let's turn to the next slide. So again, let's just recap really quick. So working with with University Alpha, we were able to use the duration, we were able to use technology space, and then we're able to put our own analysis, working together with the university to identify the areas that we wanted to focus on. In this case, we were focused on the semiconductor technology space. But from that analysis, and that amalgam of effort, we were able to identify, I'd say, 5 to 7 key families that we thought might have monetization value. And of course, this is much more manageable of a subset than than what we started with, or the denominator that we started with. And really, what we got though is this structured approach, starting very broad and applying clear filters for duration and technology, then layering in the university specific context and information. It was very effective, and it allowed us to move efficiently from hundreds of assets down to ones that truly matter, while also incorporating and respecting the nuances of the IP portfolios for this University Alpha. And once we get down to kind of what we identified as those key families, we were really able to paint with a fine-tuned brush to investigate thoroughly the individual patent families. And in particular, just to give a little gloss on that, we focused on what I like to call are the 4 pillars of any monetization effort. Pillar 1 being how strong is your patent infringement? Pillar 2, what are your validity concerns, if any? Uh, Pillar 3 is the market. What does the market look like? And is anyone using it now? Is anyone using it in the future? What does that entail? And then pillar 4, which is probably one of my favorite, is, what's the story that we're going to tell? What's the invention story? What's the creation story? Because I think a good invention and research story can really transform an, okay monetization effort into a significant one. So I'll conclude with one more slide here on University Alpha, um, which really gets to kind of the conclusion, which is, okay, we've understood what patents are most interesting to us. You've identified the 4 pillars, right? There's strong infringement reads. We feel good about validity. We've identified an appropriate market that we think has significant commercial value. In fact, in some instances, our firm has even engaged damages experts to provide opinions about potential trial damages and look at what the given market might look like regarding the accused products and future projections. That has been helpful. But once you have all this in place, the question is, well, how are we going to implement it? And of course, there's with law firms, there's the hourly rate structure. Some law firms do full contingency, which we've done in the past for the right situation. But what we're hearing from a lot of our clients is they're really drawn to kind of a hybrid contingency or the potential of a litigation funded route. And we've seen a lot of our clients gravitate towards this litigation funded route in recent years. And the reason is maybe not too surprising. First, when it's funded, the litigation ends up spending zero out-of-pocket dollars on what could amount to a multi-million-dollar patent licensing campaign or litigation. Thus, they don't need to get budgetary approval or find operating cash to pay for attorneys or experts. Um, and the second part is, even without having to pay fees and expenses, the university still maintains the ability to obtain a return on the proceeds of the licensing and monetization. And in fact, a lot of funders that we've dealt with in the past has actually sweetened the pot a bit and been willing to make an upfront non-recourse monetization payment to the patent holder right from the get-go, right from signing of the deal docs, sometimes in an amount that we've seen up to $2 million of non-recourse operating monetization payment as an incentive for doing the deal. So usually with all that, the question we do get from our clients is, well, that sounds really great, but what's the catch? We don't pay for anything and we can still drive revenue. Like that sounds too good to be true. And really, I think the answer is that, everything has a cost. And, if our clients or our university clients seek out litigation funding campaign money to pay for their fees and expenses, then the quid pro quo is that the litigation funder and the attorneys are going to want a piece of whatever proceeds flow from that litigation. And the risk profile is, I think, interesting and positive for universities because if the case fails and no money is obtained, then it's really the funder and the attorneys who bear the risk. But if it succeeds, then the attorneys and the funders and those mouths need to be fed, which would cut into some of the potential proceeds for the university. So it's those considerations that, if you do go down that route, you would want to properly weigh and properly consider. And I'll close with just all that being said. I think in a properly constructed litigation funded case, if there is success, there should be significant revenue and enough for all the parties involved to realize what they need to realize to consider it a success. So that's the story of University Alpha. I know there's a lot there, but I think the important takeaway is that there are different manageable approaches to finding out those university Rembrandts, like done here with University Alpha. So hopefully that was helpful. I'll let Veronica chime in as well for moving things forward.
Oh, thank you. That was great. Next, unless anyone has any questions, I'll keep my eye on the chat, but we're going to pivot now to talk about different Rembrandts in the attic. I think, and I will note, but the approaches are pretty different. That was a very detailed, time-consuming, thoughtful, and again, it took time, it took effort. There's a lot that goes in the background. And for the Rembrandts in the attic, for NIL rights in particular, and for trademarks, I think the approach is actually much more fast-paced, which we'll get into. So NIL rights, can we go to the next slide, please? This is a fairly new phenomena in the last 5 years in the intellectual property world. It was introduced in 2021 following the unanimous Supreme Court decision, NCAA versus Alston, which essentially gave the go-ahead for universities to begin to compensate their student athletes. I think we can all agree, finally. University involvement in NIL rights for these athletes varies. There are some main requirements. The university does have to disclose to the CSE any NIL deals for over $600. Universities can now pay athletes directly using these NIL collectives, $20.5 million from their own budgets, up to $20.5. Notably, the NIL economy in 2026 alone was estimated at $2.7 billion, with $1.9 billion of that flowing directly to the athletes. Again, these universities do need to get approval for deals over $600, and the CSC will reject a deal if the athlete is receiving compensation more than the fair market value. So one of the things that we encourage or that for universities to implement are formalized compliance programs and to monitor these NIL rights and activities pretty closely. Why? We'll talk about that. Next slide, please. So as I mentioned before, NIL rights themselves are not actually a direct source of revenue for universities. So how are universities making money and monetizing off of NIL rights? And the answer really is creativity and fast-acting responses. I'll address creativity right now. So two traditional NIL collectives that we've seen from some of the bigger D1 schools, University of Kentucky and with the 15 Club and the Thunder Trust in Marshall. These are examples of traditional NIL collectives. Both clubs offer pay-to-play tiered memberships, so you can get exclusive access to coaches and players before the game. You can tour the locker room. There are fan events. There's exclusive memorabilia. You can also make a donation and get access to, I've seen some crazy things on this website, but anything from autographed socks to access to, you can be part of a team huddle. You can get an inspirational speech from a coach, like a personalized inspirational speech. People are really creative in how they're using these NIL collectives. And of course, the proceeds go, depending on the NIL collective, a certain percentage to the university and then most to the athlete. We see a lot of these traditional NIL collectives in D1 schools, but D2 and D3 schools are really catching on and are benefiting from these programs. It's often the place of a much smaller, what I would call an NIL marketplace and partnerships. Two very small examples are Mount Union and even Mary Hardin Baylor has the Baylor Crusader NIL collective. It's very small, but that is fan involvement and booster involvement and a way to generate revenue. Next slide. Those were more traditional examples that I went through, but I want to go through what I think is really the Rembrandt in the attic for NIL rights. And my favorite example is the Arkansas Edge NIL collective. This was, I don't know if everyone remembers, I certainly remember even with my limited following of college football, if you can imagine. 2004 Arkansas versus Tennessee football game. Arkansas beats their rivals. The fans, it was a huge upset. The fans rushed the stadium. Everyone's rushing the field. It's mayhem. It's glorious. It's also a $250,000 fine to the university. So what do? In response, they actually auctioned off 6-inch pieces of the goalposts from that game, autographed indeed. These sold out quickly. I think that they were able to pay off the fine and then some. So proceeds went to the NIL collective. It was the NIL collective that organized it. It was the NIL collective that handled the sales. And proceeds went to the NIL collective. So some to the athletes and some to the schools. That is the Rembrandt. It is the school acting fast to capitalize on the momentum of the market and a fundraising boost. And by selling these autographed goal posts. But that doesn't happen in a vacuum. Can we go to the next slide, please? I'm aware that's not a Rembrandt and a Vermeer, but please bear with me for the artistic license we've taken with the girl in the pearl earring and the Michigan jersey. So like the Arkansas Edge, the key ingredient here is timing. NIL rights are huge profit generators, particularly if you're prepared to capitalize on the moment and the momentum of the event. Another example is my alma mater, UPenn, has recently formed an NIL collective. This was only possible after last year's historic March Madness run, in part due to TJ Power's powerhouse performance. But now Penn has a NIL collective. This NIL collective has been active in organizing and making sure that Ivy Madness, which is with all the Ivies, is once again happening at Penn and at the Palestra. This is the Rembrandt. This is being able to react quickly, to organize, and to respond to the momentum of the event. You need certain things to do that. You need certain systems in place. You need counsel that is versed in NIL compliance, deal structuring, contract review, revenue analytics, and IP rights. This is all an essential part of the team. Oh, Brian's going off mute. Oh, are we over? Okay.
I think
Tell me
Veronica, we're
that
gonna
we're
have to
over.
save the rest for part two in
Okay.
the coming days.
I was just going to get into my Fernando Mendoza ABBA example, but it'll have to wait for another time.
So we wanted to thank everybody for coming. There was only one CLE code, so that was the one that we presented midway through. If you forgot it or didn't write it down, you can reach out to our team and we'll make sure that you get it. Um, if there are any questions, please feel free to reach out to Veronica or myself, and we're happy to chat further. But thank you so much for coming. And then just lastly, you'll see the QR code on your screen here, which can help you with the CLE attendance verification process. So thank you very much, everybody. Really appreciated this. And if there's any questions, we look forward to hearing from you.
Thank you all. And the code again was 98712, 98712. Thank you all.